stood up for native practices. The problem was that when he went to get his unemployment compensation to feed his brand new baby, the state told him he could not have it because he'd been fired for misconduct. And Al said to me, at that point, I got my back up. I said, y'all want to fight? Okay, we'll fight. Now, the interesting thing to ask is, why was the employer acting in such a rigid and relatively tactless manner? The state, and the record presents this, of course, as a very uncomplicated secular interest on the part of the employer. That is, we don't want our drug counselors to be taking drugs, because that will undermine their ability to counsel. But if you look a little closer at the motivation of the agency, it turns out to have religious roots as well. Those of you who are familiar with alcohol and drug use treatment, even today, nearly a decade and a half later, will recognize that the entire field has religious roots. Alcoholism and treatment for alcoholism first became an issue in this country in the 19th century. The rise of the temperance movement, specifically based in Protestant theology, until about 1840, flowed into the creation of Alcoholics Anonymous. Alcoholics Anonymous, for those of you familiar with that, or any of the 12-step programs, has a specifically religious content. The recovering alcoholic or addict is expected to call upon a higher power, and the concept of a higher power flows directly out of an American religious movement called the Oxford Group, which later became what is known as moral rearmament. The central aim of those concerned with alcohol abuse was moderation, that temperance, people should just drink a little bit. In the 1840s, under the command of, at the behest of people like Henry Ward Beecher, Protestant clergy, the ideal was shifted to something called abstinence. Abstinence is a specifically religious term. It meant that you did not use alcohol in any form. And this religious base lives on to this day in the happy singing of a group called Up With People, who pop up every now and then, serenading school children with cheerful songs about being happy and patriotic. So this religious substrate had been overlaid by a very specific internal schism that was going on precisely at this moment, and that had all the intensity of battles against heresy within any religious movement, and that was the so-called controlled drinking controversy, which broke out in the 80s when researchers financed by the Rand Corporation did a longitudinal study of recovering alcoholics and reported that a significant number of those who were alcoholics could, after a period of time, return to social drinking without suffering relapse and becoming alcoholics again. Scientific dispute, obviously subject to empirical debate about the interpretation of the evidence, but it quickly became a religious dispute because the Sobels, which is the name of the Rand researchers, and those who supported them, were treated not only as heretics, but almost as demons, people who were attempting to destroy the sobriety of people who had found serenity through the 12 steps of Alcoholics Anonymous. And when you read the depositions in the Smith case, and the referee asks the agency why they had fired Galen Black, the first words that come out of the director's mouth are, "There's no such thing as controlled drinking." Fascinating thing about that, of course, is that Galen Black's case didn't present that issue. He had never argued that he could drink. It had to do with religious use of peyote. But the absolute rigidity with which the agency responded to this crisis came directly out of their own fear that the entire basis of their existence was being challenged by a rival faith, if I can use that term. The state of Oregon responded in a very rigid manner, refusing to compromise, for reasons, once again, that had nothing to do with the facts, but had to do with the state's own constitution and the fact that under Oregon law, the state was required to be absolutely neutral among religions, which meant that if an exemption, or could possibly be interpreted to mean, that if an exemption from the law was given to the Native American Church, the next exemption would have to be granted to a group called the Neo-Industrial Church of the Universal World Comforter, which worshiped as its central sacrament cannabis sativa, the marijuana plant. And the Universal Church of the Neo-Industrial Church of the Universal World Comforter was very anxiously pursuing their case in the courts, and the state of Oregon was concerned that if it compromised at all with a small group of peyotists with whom they had no genuine quarrel, the next thing would be a legal finding that marijuana could be smoked openly. Finally, the state of Oregon was represented throughout this litigation by its Attorney General, a man named Dave Frohnmeyer. Frohnmeyer was son of a very prominent family in Oregon. His brother was head of the National Endowment for the Arts under President Bush. And Frohnmeyer, a brilliant, fascinating lawyer, had tragic personal circumstances that clearly, I think, influenced his response to this litigation, because after he had married and had 5 children, he and his wife discovered that all 3 of his daughters were sick with an incurable, fatal genetic disease that had never appeared in either family before because it was so recessive. The Frohnmeyers very quickly responded to this by becoming the foremost advocates of research and treatment for this disease called Fanconi anemia, probably in the world. They set up the Fanconi Anemia Research Fund, which is now a significant player in funding research, organized the first scientific conferences on it, organized a support group for families, and a summer camp for families affected by it. They simply took a position that they were not going to let their daughters die. And this obstinacy, this tenaciousness, I think, spilled over into Frohnmeyer's conduct of other litigation. The other fact that shadows the record is the story of Bhagwan Sri Rajneesh. I'm curious how many people have ever heard this name, Bhagwan Sri Rajneesh. Bhagwan Sri Rajneesh had this story occurred anywhere near a major media center. It's a mark of how isolated Oregon is, that people don't know this guy. Because I think if it had happened on Long Island or anywhere in California, Bhagwan Sri Rajneesh would be even better known than Joy Buttafuoco. It's one of the most extraordinary stories in American history. Bhagwan Sri Rajneesh was a Hindu holy man who came to this country and decided to build a new city in the middle of the Oregon desert. And very soon had 5,000 people living there with a conference center, movie theater, dance hall, meditation chambers, and we now know also germ warfare lab where they were attempting to culture the AIDS virus, extensive bugging equipment, secret tunnels to survive a nuclear attack, and a number of other very, very extensive store of weapons. The Rajneeshis then attempted to take over the county government of the county in which they lived, so they could change the name of it. First they took over the town of Antelope, Oregon, and changed the name to Rajneesh. They took over the community center, a former Episcopal church, and changed its name to the Adolf Hitler Community Center and Toxic Waste Dump. They wanted now to take over the county. They didn't have enough voters on the ranch to win the election. So they decided that the way to win was to culture salmonella virus and poison food at all the local restaurants on the night before the election, which would mean that the local voters in Wasco County would be too sick to go to the polls. All the Rajneesh people would vote and they would win. At the last minute, this plot was foiled in part by Dave Frohnmeyer, by the Oregon State Attorney General's office, who had informants inside the ranch. Rajneesh attempted to flee eventually, was arrested at the Charlotte airport trying to get out of the country and go to the Bahamas along with a large supply of weapons, several $100,000 in gold and jewels, and a number of other things. And it is impossible for me to believe that anyone who had dealt with this religious cult could not come out of it thinking, that perhaps we shouldn't take at face value the assurances that religious leaders give, that allowing them a little leeway around the law would not pose a danger. All of these things went to create, I think, a very artificial conflict which the court used for its own purposes. And reading the papers of Thurgood Marshall, it is quite clear that Justice Scalia, as early as 1989, is massaging the case into a shape that will allow him to enact the so-called Smith rule. The aftermath of the case is as fascinating as the facts that led up to it. The mainstream churches united in opposition to the Smith rule. It reminded me of the famous quote from Tocqueville, who said that if a politician in the United States attacks one church, then people will still vote for him, even people that belong to that church. But if he attacks all the churches, no one will vote for him. And the mainstream churches united, demanded that Congress repudiate this decision, and formed a coalition to pass the Religious Freedom Restoration Act. Their very first order of business in putting this coalition together was to make it clear that they did not want any participation by Native Americans or people who use peyote, because that would be controversial. The law was passed, and in the case of City of Bernie, Texas versus Flores, the court struck it down, and it reaffirmed the Smith rule. Now, my position is that if you read very closely what the court said in Bernie, it's reaffirming the Smith rule between clenched teeth, because the court, I think, regrets that it went as far as it did. The tone of the Bernie opinion reminds me of the famous story of Ring Lardner, in which the little boy tells the story, and he and his father are going somewhere. At a certain point, the father's looking at the map, and Lardner says, "Daddy, are we lost?" I asked tenderly. "Shut up," he explained. The court reaffirms the Smith rule, but doesn't really follow it. And that leads to the final irony, which is that today, thanks to a separate statute, the religious use of peyote is protected under federal and state law, but the mainstream churches who excluded the peyotists are still struggling for a formula that will undo what they consider to be the damage done by the Smith case. It seems to me that Smith is really the first pale shadow of the kind of cases that we will face in the 21st century. Because while peyote religion is quite different from mainstream Protestantism in this country, it is important to remember that the Native American Church is an offshoot of Christianity, and specifically worships Jesus. The plaintiffs in the next case the court heard, the Church of the Lukumi Babalui versus Hialeah, that is a Santeria or voodoo sect, are also offshoots, though with African features, of Christianity. We are now going to face a series of disputes over religious freedom that will involve cases that have religious groups that have no Western roots at all. Diana Eck, the religious scholar at Harvard, now argues that the United States is the most religiously diverse nation in the history of the world. Every major world religion is strongly represented, and some that previously have not been major world religions, such as Scientology, are also represented here, all of them making claims for respect and observation of their needs. The question that arises out of Smith is whether the Supreme Court is a trustworthy guardian of American values of religious liberty. We have, I think, had a sense in this country that we can count on the court as a referee to prevent the oppression of minorities by the majority. In Smith, the court signaled that it was tired of this role. The response is probably not a helpful response to pass more acts like the Religious Freedom Restoration Act, telling the court that it was wrong and it needs to apologize. It's not going to do that. Justices of the Supreme Court are appointed for life. They don't care what we think, to put it in capsule form. Instead, it seems to me that all of us in this country are going to have to go back to the really radical Madisonian roots of religious freedom in this country, and the sense that religion really is a private matter, and the state, and indeed even majority civil society, doesn't have a whole lot of business getting involved and deciding what's legitimate and what isn't. If we don't do that, if our decision-making institutions, school boards, legislatures, city councils, and Congress don't internalize that, free exercise is liable to be in crisis for most of the next century. And it is not clear whether what will emerge will be anything that we would recognize today as the free exercise. I've gone over my 20 minutes, but I will be glad to take questions now. This will be on the exam. It's usually the first question. Yes?
I'm not entirely clear as to what the basis of your objection to the Smith decision is. Whether it's because you think the Smith court misinterpreted the meaning of the free exercise clause, or whether you think the Smith decision just violates some sort of general moral principle, or is just not good public policy.
Well, I would say
Based,
yes to all three. Yes, go ahead.
You mean it's both?
Yes. I think let me just say, first of all, I read a really interesting book by Justice Scalia called A Matter of Interpretation, Federal Courts and the Law. And Justice Scalia says, by God, we have no law in this country unless we are textualists and rely on the Constitution's text. Well, the part of the text that I'm curious about says, Congress shall make no law abridging the free exercise of religion. I think that term has to have some meaning. I don't think it is appropriate, even within Scalia's own hermeneutic, to apply that to say, well, all it means is that you can't pass a law restricting people from bowing down to golden calves. Okay? I think that is just poor constitutional law. And particularly when you consider, for those of you who have some knowledge of free exercise law, when you consider that the primary precedent that Scalia's opinion relies on is Minersville School District versus Gobitis, a case that is overruled. And indeed, if one of my second-year First Amendment students were to write an exam answer relying on Gobitis, I would fail them. The case is not good law. So I think that as a matter of constitutional interpretation, it's inappropriate. Secondly, as a matter of procedure, I don't believe the court should reach out to decide a question without letting the litigants know that this is the issue. And if the court really felt that we should have a decision about whether the Smith rule is the appropriate way to manage religious freedom in this country, it should have done what the court did in the Brown litigation, and that is put the case down for re-argument and ask for a briefing on that question. There isn't, I've read the entire record, there's not one word in the record, in the oral argument, in the briefs, anywhere, to suggest that this was the issue. So that's the second thing. Thirdly, I think it is, as an American, I find it objectionable to say that we really mustn't worry anymore about the problem of religious minorities being oppressed by the majority. That's just one of the consequences of democratic government. And as you, I'm sure, know, that language is used almost in hoc verba in the Smith opinion. And fourthly, you know, getting to your last level, public policy, I just think it's a bad way for us to go into the 21st century, given the religious diversity of the country that we're going to be living in. Does that?
Could I just respond to your comments?
Sure.
And see if you would like to respond first? Originally, the free exercise of religion was simply a synonym for freedom of religion, for rights of conscience. It had no special meaning, and
respond, no, I'd like to take questions from other people, but your point of view is one I'm familiar with. I don't share your view of the historical roots of free exercise. I don't think that's a correct statement, though I admit it's a historically debatable question. Rob?
I don't know that much about peyote, and I wonder if you could describe the ritual and what the impact is on a person after they take it. Justice O'Connor in Smith says, well, we should apply more rigorous scrutiny, but even so, Oregon is justified because this is really dangerous. There's a compelling governmental interest, I guess, on accidents on the highway and stuff like that. But could you just, because I imagine a lot of people here like me don't really understand the ritual and don't really know what peyote is and don't really know how high it makes a person and things like that.
I'd like to respond to that on two levels. First, the general peyote question, and secondly, what is O'Connor trying to say? Because I think her opinion is an interesting one. First of all, the peyote ceremony, I don't think it evolved for this reason. What's fascinating is that as it exists today, it seems to have a lot of safeguards. First, to protect people involved in it from bad results. And secondly, to prevent the kind of danger that you mentioned with road accidents and so forth. What happens in a peyote ceremony, and the traditional Native American church ceremony is only male, is that male worshipers gather at sundown in a teepee, or perhaps some other structure now, although it's called a teepee ceremony. There is singing and drumming for a significant period of time, which I'm wanting to say, I don't have the sources in front of me, but I'm wanting to say it's 3 or 4 hours of singing, drumming, and prayer. At the end of this point, at the end of this period, peyote buttons, which are dried peyote cacti, are brought in and passed around, and worshipers have the opportunity to eat none, or usually up to 4, which is not really a huge dose. The problem with peyote as a drug is that it really tastes bad. And one of the functions of this wait between the beginning of the sermon and the initial ingestion is that it allows the worshipers to, I'm not saying, I don't know and I don't not even think that this was done for this reason, but it does in fact allow the stomachs of the people who are there to empty so that they don't have anything else inside them, because it would be very common to become nauseated if you ate even a small amount while you had something else in your stomach. They then return to drumming and singing for another couple of hours. It's somewhere between 2 and 4 hours, at which point peyote buttons are passed again, and once again it's customary to take from 1 to 4. Again, not a large dose. Now, having said that it's not a large dose, it does have some impact, and I myself have never been invited to a ceremony. If you know Native people, it's really not the thing to do to go around and say, wow, you guys have such cool ceremonies, can I come? I've been waiting for my invitation, it hasn't arrived. But the people I know who've been in it and the published accounts say that there are, I wouldn't say hallucinations. Peyote is called a hallucinogen. There's no question that in high doses it can produce hallucinations because one of the active alkaloids is mescaline. But in the doses in which it's usually used in the ceremony, it produces something more subtle, visual or auditory distortion. One thing that's very commonly reported is that the fire, which is burning in the middle of the teepee, becomes the focus of the worshiper's attention. It seems to take on a richer quality than just the ordinary campfire. The music, one becomes very involved in the music, and the opportunity is presented for a certain kind of introspection. It is very rare, and indeed I have not been able to find a documented case, though I'm not saying there isn't one. I keep, it's like the case Perry Mason lost. You keep hearing it's out there, but I've never found it. It's very rare to find a case of someone in the context of the ceremony having a negative reaction or needing medical attention or anything. I don't know of such a case. The ceremony then goes on until dawn. Okay, so that's another 3 or 4 hours after the final ingestion of peyote, at which point the teepee is opened and the worshipers gather for quite a lengthy breakfast. And ordinarily a peyote ceremony is held on a Friday or Saturday night, because the breakfast and the fellowship that follows take most of the morning. And that, again, has the effect, whether by design or otherwise, of permitting the effects to dissipate before people are operating machinery or anything else. So there really is nothing in the record to indicate that there's a substantial problem of people harming themselves or behaving in a dangerous way as a result of the ritual use of peyote. There's no question, and no one disputes, that peyote itself, if you had it, and it can be smoked, though peyotists don't do it, could produce bad effects. So that the peyote church has never denied that the state has an interest in regulating traffic in peyote, who can possess it, and so forth. And the Native American church has been very cooperative with the Drug Enforcement Administration in trying to prevent any peyote from getting into illicit channels. There's virtually no illicit traffic in peyote because it's such a bad drug. I mean, people who want to get high can do so more quickly, more easily, and with fewer bad effects by taking, synthesized hallucinogen. I think during the entire decade of the 80s, the DEA seized 3 pounds of illicit peyote. Compare that to the amounts of marijuana or LSD that are seized almost yearly. It seems to me that Justice O'Connor's opinion has to be read not so much in the context of an empirical judgment that bad effects might follow from peyote, but in terms of her response to Oregon's argument that because of its unique constitutional provisions, it had a special interest in not providing an exemption. She doesn't make this clear, but I can show you the language where she says Oregon has an interest in not providing an exemption. And I think that's what she's referring to, because otherwise, if you read the opinion, there seems to be a piece of logic, because exactly what you're talking about is missing. She doesn't say it's really dangerous because. And I think that's what's going on.
Did the court have any friends of the court or anybody that explained the ceremony you just explained to the justices, or was that not a piece of this?
No, there were, the Native American Church itself, which wasn't a party to the litigation, filed an amicus brief. The important thing to realize, as was made, the point was made by Professor Laycock of the University of Texas, is that had there been any inkling that the Smith rule was in the offing, there would have been substantially more amicus briefing. And in fact, the total number of amicus briefs was quite small. Nonetheless, the Native American Church did provide a very lengthy discussion in its amicus brief of how peyote was used and its consequences according to the literature. Now, the question arises of how much attention the court paid to that. I fear the answer is very little, and the reason that I say that is because at a certain point during the oral argument of one of the 2 iterations of Smith, Chief Justice Rehnquist says, well, now when they smoke this stuff, what happens? So that I think the court was very far removed from any real factual context. And of course, simply as a matter of constitutional theory, that's one of the hazards of deciding a case where there isn't an appropriate factual record.